Judge of Appeal and Commissioner, and Karibu.
Good morning, my name is Charity Kisotu, a commissioner. You are welcome.
Thank you, Madam Commissioner.
Isaac Ruto is my name, a member of the JSC.
Thank you, Commissioner.
Good morning, my name is Caroline Zilani. I'm a commissioner. Karibu.
Thank you, Madam Commissioner.
Good morning, David Majani, Judge of the High Court and Commissioner. Welcome.
Thank you, my Lord, Commissioner.
Okay, thank you very much, Commissioners, for that introduction. Before we delve into the interview where the Commissioners will be engaging you on your application for the position of a judge, please tell us your county and your ethnicity.
My county is Kericho County, ethnicity, Kalenjin, subtribe, Kipsigis.
The first set of questions will be asked by Commissioner Jerome Ashali.
Your Honor, 3 questions. Now, I noticed that you at one time was assigned duties at Judiciary Training Institute, where you are for 2 years approximately. Now, could you tell the Honorable Commission the key lessons that you learned there, lessons stroke experiences, key, not everything, and how that will help you as you conduct your duties as a judge if you become one?
Vice Chair, Commissioner, thank you for that excellent question. And as rightly indicated, I did serve at the Judiciary Training Institute as a portfolio lead in charge of training for judges. During my tour at the Judiciary Training Institute, there were valuable lessons that I learned. Amongst them was 1, the need for capacity building in terms of service delivery. 2 was equally the importance of case management and strategies that judiciary has deployed in active case management. I equally learned ably about general management of a master diary in order to reduce the absence of judges, because that was my docket, to plan a master diary and ensure that we reduce absence of judges from the station without necessarily affecting court work. But amongst the important ones that deal with judges, specifically dealing with judges, is that the category of judicial employees of judiciary called judges have a special position in the society, in the sense that there are so many restrictions that they go through on a daily basis, and somehow they have to manage those restrictions within the confines of their calling as judges. And therefore, Judiciary Training Institute also equipped me with better communication skills, ability to be visionary in terms of work delivery, and the presence of the many guidelines issued by the Commission and policy documents that actually helped us in terms of delivering on our services.
Right. Then, again, pursuant to that, you are chief officer in the office of the principal judge. Again, I would be interested in hearing the experiences learned there and how you'd also apply them.
During my stay at my tour of duty at the principal judge's office as acting chief officer, one vital lesson that I learned was that occasionally you'd be called upon to perform a task that is larger than you. But if you're well prepared and have a team that you work with, you can easily deliver on any mandate that is assigned to you. I'll have an example to illustrate that point. Towards the end of the Emeritus Chief Justice Dr. Willie Mutunga's time, it took a bit of time before Emeritus Justice David Maraga was appointed. In between, we do not have a sitting Chief Justice. And as per the tradition of the superior courts, they were entitled to have their annual colloquium. I recall, Vice Chair Commissioner, that with the assistance of the then acting President Supreme Court, my Lord Justice Ibrahim, we were able to actually conduct a successful colloquium. We do not have the Director Judiciary Training Institute at that time because he was bereaved. I took the mantle as the Deputy in charge at Judiciary Training Institute and the support of my Lord Commissioner Justice Ibrahim. And we delivered on our task. It was beyond me, but somehow with a team, I learned you can do more.
Yeah, fair enough. Now, so my last question, which I'll break it down into two, with those experiences that you've had, besides, of course, now being also a chief magistrate, now tell us how you go about it in deploying those experiences into becoming an impactful judge. That is one. Then, secondly, besides what you've said as achievement that you've realized, give us critical achievements, 2 or 3, that you think support the fact that you would become an impactful judge.
Thank you, Honorable Vice Chair Commissioner. Currently, we have a blueprint that helps us navigate the complex judicial system that we're operating in, the social transformation through access to justice. From the experience and knowledge that I gathered at Judiciary Training Institute, as well as at the Office of the Presiding Principal Judge of the High Court, number one is that I will continue to impart independence and exercise independence in protecting people's rights, and especially those categories who are vulnerable. Number two as well is that in the course of my training and in the course of my tour in the two institutions, I learned prudent financial management, which would help me as a judge to make the best use of the resources that the station has been allocated. Equally, with that wide experience and exposure at the two institutions, I know for a fact that I will be able to have positive cooperative dialogues with other stakeholders towards organization and administration of justice. And of course, I'm a champion of social justice. I believe in equality, and from the lessons I learned, I know I'll impact as a judge in those positions.
Thank you, Honorable Chair. Honorable Mikoyan, how is Eldoret?
Eldoret, the weather is better than Nairobi.
Oh, it's not as cold, or it's not as hot, or what?
It's not as hot.
It's not as hot.
It's
okay.
fairly cold.
All right. Now, just a few questions from me. In matters of employment and labor relations, what is severance pay?
Number one, at the time that an employee is parting their employment contract to the employer, there are a number of claims that an employee can lay, and severance payments particularly deal in a situation where the employee has not been properly procedurally processed for termination.
Okay, I'm not sure about that, but yeah. And when is one paid gratuity?
Two scenarios, on retirement or at the end of their contract, if it is provided for.
So on retirement, you're permanent and pensionable, you get a gratuity?
Yes.
All right. You need to familiarize yourself with this area of the law, because you know when you become a judge, really, you're going to encounter so many other, it will not just be confined to one area of the law. How is severance pay calculated?
Severance pay, I have not dealt much with ELRC matters.
Mm-hmm.
Yes, and I'm not very quite conversant with that area.
Right, yeah, but you know, as lawyers, because bottom line is that we are all lawyers, we cannot really get away from saying we don't know that branch of the law. Under the Employment Act, there is due process that is anticipated before an employee can be laid off. What is that due process?
So an employee, upon an employee is entitled to a notice informing and communicating.
Right, notice, one.
Yes, notice,
Mm-hmm.
tabulation of dues.
Tabulation of dues.
Yes, if there are any dues that are pending, be it maybe leave days that have not been taken.
Sorry, maybe I wasn't clear. At the point of being disciplined or undergoing a disciplinary process, there is due process that is anticipated by the Employment Act.
Yes.
And so the question is, what is that due process? One, you've said they must have been served with a notice.
Yes.
Yes.
Then the second one is the principle of natural justice, that he must be given a chance to be heard.
Right. Right to be heard.
Right to be heard.
Yes.
Right to be represented.
Right to be represented.
Yes.
By whom?
Either right to be represented either by a council, or if it's a union employee, by a member of the union, as per their union.
A shop
regulations.
steward, for that matter.
Yes.
Anything else?
Not that I can recall at the moment.
All right. Is there a right of appeal?
Yes.
Okay. Thank you. That's all from me.
Thank you, Honorable Mikoyan. I confirm that I think when you started your career in Nakuru, I was working there, yeah? I worked with you. Now, you want to join the High Court, and the courts have been criticized for easily or casually declaring statutes or part of the statutes unconstitutional without due regard to the fundamental underpinnings into the process of making the law. What is your view on this?
Thank you, my lady, Chair, Chief Justice. I'll answer that question in three parts. First and foremost is that the issue about perception, which is neither here nor there, because at the end of the day, the court must have some parameters to look at before any decision is made, either to invalidate any statute or any provision of the law. I'm talking about in the High Court has jurisdiction under Article 23, under Article 22 and 23 as well, to not only interpret the law, but at the same time look at the legality, because the general principle about statutes is that all statutes are presumed to have been promulgated in a lawful manner and promulgated towards the purpose and objective and the spirit of the Constitution. However, if it comes a petition that a particular statute either limits the rights in the Bill of Rights or lacks one of the elements in making of laws, then the High Court would take the Constitution on one side and the statute on the other side and compare, and then make a decision. Why we are criticized is that hardly Kenyans maybe take time to read the actual decision of the court. So mostly it is based on what is reported elsewhere, other than what the court has actually indicated in their judgment and ruling.
Yes, and what would be the test or principle would you apply if such an application or petition was brought before your court?
The principle of legality.
In what sense?
In the sense that I will then look at under Article 23, I believe Article 23, I look at what is the purpose of the statute that has been promulgated, and how far does it go in contravening any provisions of the Constitution? And based on that, if it does not meet that, there's a three-part test that I have to look at. And if it doesn't meet those threshold, then I would invalidate. The organ that has the jurisdiction or the authority to prosecute has declined to prosecute the same, and therefore a party can seek from court.
What does a successful person, a person who prosecutes at the thought of malicious prosecution, need to prove?
Okay, I get you.
Yes.
Thank
What
you.
do they need to prove?
Thank you.
To be successful?
Number one, they must prove that there was an arrest. Number two, they must prove that the arrest was malicious. There has to be an acquittal in the charges. Yes. And that there was no reasonable cause to therefore prosecute.
Prosecute a reasonable cause. Now,
charge. But under 215, an acquittal under Section 215 is materially different in the sense that depending on the defense that you have surmounted, it could have caused doubts on the prosecution's case.
So how does that relate to the thought of malicious prosecution?
Yes, so there is a reasonable cause for you to have been charged if you are acquitted under Section 215. There was a reasonable cause, but maybe not proved beyond reasonable doubt.
So what happens to the thought?
What happens is that under Section 210, you would succeed in being awarded damages, and you would not succeed if you are acquitted under Section 215.
Okay, thank you. Thank you very much.
Thank you, Honorable CJ. Honorable Mikoyan, sorry, I've followed your work and I know what you have done as a judicial officer, as a leader in the judiciary. I've worked with you, so I may not have many questions to ask you. I've also read your sample writings. What I would like to know, in your CV, you have said that between 2017, February 2017 and April 2019, you were acting chief officer in the judiciary. What office is that?
Thank you, my lord, for pointing out. Perhaps it's an error, but I was the acting chief officer at the High Court in the office of the principal judge, pursuant to the High Court Organization and Administration Act.
Okay.
So it creates a position of that nature.
So this is internal, because in the job groups I have not seen that title. Okay, I understand. You are attached to the office of the principal judge.
Correct, my lord.
Okay.
Yes.
Assisting the judge in his administrative work.
Correct, my lord.
Okay.
Yes.
Now, as we, okay, before that, you did an election petition, an MCA matter in Eldoret.
Correct, my lord.
What was your experience, and specifically, the difference or experience you had vis-a-vis the usual criminal cases? What are the special difference of election petitions from the other cases?
Excellent question, my lord. Number one is that, first and foremost, that was my first election petition to handle. And election petition, that the one I handled, was a very simple and straightforward matter. It was just an issue about timelines. There was nothing more than that. However, the intricacies that comes with managing an election petition supersedes what you expect in your daily court list, be it civil or criminal. So number one, there was a lot of pressure in terms of timelines to meet. Number two is that the election regulations dealing with that particular petition are quite specific. They are quite specific in a nature that sometimes litigants can see where their issue is going, and then they decide to derail you along the way with a plethora of applications that were coming in. Even up to the stage when I was about to deliver my judgment, there were still parties coming on board seeking to put in further applications.
Okay.
Yes.
Yes. So what is your understand in terms of time? What did you notice, or what did you experience?
What I experienced was actually time-bound proceedings are far much more easier to handle than unlike the open-ended proceedings. Yes, because along the way people do understand that they are running out of time and they have no option. You have to make a decision.
And it's mandatory.
Yes, correct.
Okay, thank you. Lastly, we also look at your social community involvement. So I asked myself, here you said you are chairperson of Eldoret Men's Conference. I mean, Eldoret Men's Conference, and then in the judiciary or something like that. So I was asking myself, is this man assistant to Stephen Leto of the Men's Conference? And then I saw again patron person Eldoret Courts Women's Conference. So I don't understand, what are those bodies?
My lord, a very good question, and thank you for that. We are dealing in a currently post-COVID, the post-COVID period in judiciary has presented us with many challenges, and a lot of them, including issues that are related to mental health. And what we did at our station level was to create groups that we can do debriefing without necessarily having funding from judiciary. So the men's group is called the Men's Association, and these are all the men working at Eldoret Law Court, staffs, judges, and magistrates. And the women's group are the ladies who are also working at the station. So they get their time to discuss their issues that would otherwise affect delivery of service. Equally, we do that as men. So that's the patronage that I was referring to.
Quite unique. And lastly, you are doing another program for, and I wonder where you get the funds from, sponsoring at the station a child feeding program for children who come with their accused mothers in court.
Thank you again, a very nice question. There are two aspects to it. One is that it's an out-of-pocket thing that I do at the station.
It's personal. It's personal.
Yes, it's personal. Yes, so we have mothers who are accompanied by minors, and because of their vulnerability, I'm able to take care of, at least mitigate against their stay within the court station. I recall even December 2023, we reached out to UNODC, and they sent us supplies, which lasted us about 8 months towards that program, just to give them a biscuit and a soda for the kids. And we also provide for those children who are in conflict with the law when they come for hearings.
Thank you very much. And lastly, thank you for hosting the JSC team, which visited Eldoret last year. And you assisted in managing the engagements. We appreciate that. All the best.
Thank you, my lord.
Chair, good morning once again, Your Honor.
Good morning.
And I wish to also thank you for hosting the JC when you are down there and engaging with stakeholders. We noticed that you have a very vibrant way of engaging the CUCs. And thank you for also taking up the initiative of supporting the vulnerable, coming up with your own initiative, even reaching out to UNODC to support the vulnerable. So must commend you for that. As a judge, you are expected to promote alternative justice system. That is what the Constitution has asked the judiciary to do. You find a murder case before you, and parties come and tell you that we have decided to go to the elders, and the elders have agreed that we need to settle this issue out of court. The AJS team has developed what is known as the agency theory of jurisdiction. How will you try to determine whether that AJS system had the jurisdiction to determine that dispute?
Thank you, Commissioner. A very excellent question. The principle of agency in an alternative justice system is primemost, and it sets apart the manner in which alternative justice system is conducted vis-a-vis the traditional courts that we have. For each and every other traditional method, for each and other every common court proceedings that we have, we always start with jurisdiction. But for the agency theory, it's primarily sets the questions as to are the parties consenting to undergo the alternative justice system trials. In a murder case, and I know there's jurisprudence from the High Court, there are certain times that parties have been given a chance upon their request, and actually they successfully conclude on the trial. The two basic things that we may look at is there a policy that prohibits that particular matter of case being referred to AJS? And if there is none, I would then allow them to pursue. Is there any statutory law that again negates against having that matter taken to an alternative justice system? If there is, I would decline. In the absence, I would allow.
Okay, that's it. Maybe you may need to refresh your memory on that. Who is an intersex person? And are you aware of any court decision with regards to intersex persons and any legislative amendments on the issue?
Thank you again, Commissioner. That's a good question. Let me start with if I'm aware of any case.
We could start with who is an intersex.
Yes. An intersex person, to the best of my understanding, is someone who whose biological gender has more than one biological gender, and a decision that comes to my mind is the Katiba Institute case against NGO Coordination Authority. That is the one which comes to my mind, and I think it was dealing with the issue of the right of a group of people to register a particular name for use as a society. That is the case that comes to my mind.
Were intersex persons part of that particular case? Intersex persons. What's the difference between intersex and gays and lesbians and transgender?
They were part of it because the case basically had LGBTQIT involved. So the I stood for the intersex persons.
Okay. African countries that have sued other countries at the International Court of Justice on issues around genocide. Could you name the African countries and the countries they have taken the case before the court on their behalf? Sorry.
On the issue of genocide.
Genocide, yes.
The one which comes top to my mind is Burundi and Rwanda.
Mm-hmm.
Yes. Burundi.
Let me then just take the question closer.
Yes.
On behalf of other countries that are not within Africa, 2 African countries have sued other countries outside Africa. They have sued on behalf of other countries outside Africa. 2 countries, yeah.
No, I'm not aware about them.
Okay.
Yes, I'll need to check on that.
Even the recent one, Israeli, is between Israeli, South Africa on behalf of Israel. Okay.
Yes, I was not aware about that one. Yes.
Thank you. All the best.
Thank you.
Thank you, my lady. Once again, good morning, Honorable Mikoyan.
Good morning, Commissioner.
Yes, I have no bone to pick with you concerning your performance. You are doing a very good job. Testimony to what I've heard about you and what I know about you. Your performance is quite good as a court and even at the personal level. Your own output is at 14% against what is expected of you, that is 9%. So you are going above the expectation. That sounds like CBC. You're also, overall performance is good at 150%, case clearance rate 134 against the national average of 104. And the court productivity is also quite high, almost double the national average. I think that is commendable, and I had to say that. The question that I have for you, there's a quote I want to read you, and then I want to hear your comments on that quote. So the quote goes, if we really want high performance in our organization, the solution isn't to entice people with a bigger carrot or threaten them with a longer stick. We need to understand the intrinsic motivation. I will read it again. If we really want high performance in our organization, the solution isn't to entice people with a bigger carrot or threaten them with a longer stick. We need to understand the intrinsic motivation. Now we have a performance measurement framework in the judiciary. Do you think it's a reflection of this quote? If you think so, tell us why. If you think not, tell us why and how we can improve it.
Thank you, Commissioner Olwande, for that question. And thank you for acknowledging what Eldoret does. On behalf of Eldoret Law Court, I'll carry back the remarks.
Mm-hmm.
The answer is both yes and no.
Mm-hmm.
It is yes for the simple basic reason that judiciary has laid bare not only our mandate through policy documents, but have also detailed through guidelines what we are expected to achieve.
Mm-hmm.
And beyond that, the results that have been, the goals or targets that have been set are rewarded whenever the individuals attain those marks.
Mm-hmm.
Or attain the goals. So yes, judiciary, the Judicial Service Commission has understood clearly that the members of staff who are serving in judiciary requires capacity building by putting indicators on what they are expected to achieve. And actually, a lot of times, those targets are met. But again, why is it no? Is that the performance measurements that currently are in place still requires further interaction or interrogation to deal with the two aspects that have been left out. One is the quality of the work that is measured at the end of the day. Two is the weight of the weighing of cases, of the respective cases, towards an objective assessment. So for those two reasons, our PMMU still requires, our performance management measures still requires to be improved.
Okay. Now for what you said it doesn't, how do you think, any suggestions on how we could improve on it?
One suggestion I would have is just the way we've done with election petitions.
Mm-hmm.
If we could indicate timelines for determination of different category of cases, that might be a good indicator to know whether that target was met or not.
Mm-hmm.
So that if you conclude the matter outside the target, perhaps it doesn't earn you any marks. And I think everyone would gear towards meeting their timelines.
Mm-hmm.
So that will be one for me. Two might be coming up with special categories of specialization of courts, so that those, for example, who are very knowledgeable in particular area, field of area, like example, employment, labor related, they can be in that docket dealing with that particular type of cases. And I think that will also help us in achieving our targets faster.
Yes. Okay, thank you. Thank you, my lady.
Thank you, Commissioner.
Thank you very much, Honorable Chair. I have only one question for you, Your Honor. Could you state for us 3 principles in Article 232 and tell us how you will mainstream them in your workstation as a judge?
Thank you, Commissioner. Article 232 sets down the guiding principles that we are guided in civil service. And the topmost for me, one is professionalism. At all times, I'm supposed to work within the confines of my work in a competent, diligent, and effective manner. Number 2 is about the issue of integrity. And to that, I'm addressing how I conduct my proceedings, how I conduct myself, and how I promote public confidence in the work that I do as a judicial officer or as a judge. And number 3 is accountability. And on this one, I'll be accountable at 2 levels, at the decisional level, on the decisions that I make at a personal level, and also presenting my decisions, written decisions, to the public, either for critique or otherwise. So I'll be able to demonstrate them in those 3 areas.
Thank you, Chair. Yes, Mheshimiwa, you've worked in the judiciary for quite a bit of time. You've risen to the position of Chief Magistrate. Now, you have been around during this period of between 2010 and now. And what are the key drivers of reforms in the judiciary in the last 10 years?
Thank you, Commissioner, for that question. The impetus of reforms in judiciary were ushered in by the promulgation of the new constitution. And there was an imperative arising from the constitutional promulgation that judiciary had to then change its culture from the way it was working before the new constitution was promulgated. Among the things was that judiciary was now to be an institution that is accountable to other arms of government and to the public. Again, the leaders, the officers in judiciary were then expected to subscribe to Chapter 6, which was not there before, on terms of integrity and leadership at the station. And there was a general cry on by Kenyans to have a transformative institution that was responsive to the needs of the people. So as part of social justice, judiciary had to take up that mandate and rework how it was delivering its services. Part of the drivers for change in judiciary was internal also, because the manner in which judiciary looked at itself had to be changed for them to deliver. So there were also internal drivers that led to those changes that we noted.
Reports indicate that 20% of Kenyans, less than 20% of Kenyans actually access the form of justice that we avail. what could be the challenges facing the 80% of Kenyans that they are not coming over, and what would be your suggestion how to resolve the matter?
I'll answer that question based on my, not any empirical study, but based on my perception and interaction with services in judiciary. Number one, which is topmost, is the waning public confidence in judiciary, such that occasionally litigants do feel that you may not get justice when you take your matter to court. It will stay like for too long before eventually a decision is made. Access becomes also another issue in terms of the distance between courts. That is a physical access. So the distance between courts, sometimes they are far apart, and when you couple that with the costs and the fees that are required, sometimes it denies a category of people the chance to come to court. We can also say that there are outside there flourishing other alternative justice mechanisms that are serving the people. So on depending on the area that you are in, you may find traditional methods of dispute resolution, and they are working for them. So they are able to access that, and it's cheaper for them. They would then go to those particular areas.
Okay, thank you.
Thank you, Chair. Honorable Mikoyan, please tell this commission what how you describe your relationship with members of CUC in Eldoret Station, and particularly the probation department.
Thank you. Thank you, Commissioner, for that question. CUC is part and parcel of the inclusiveness and shared leadership at the station. And for us, we relate in two areas. One is about just the general organization and administration of duties through the Court Users Committee. But the other legal aspect is us requiring from them periodic reports, be it for pre-bail or for pre-sentence hearing. That's how we relate, and it's very cordial and they're very useful.
Have you in the recent past had any conflict with the probation department members?
Not any that I know about.
Okay.
Yes.
It is alleged that there are changes that you introduced at the registry that restricted that area to staff only, and that did not sit well with probation members who felt they were being discriminated. What do you have to say about that?
Thank you. That's a very nice question, Commissioner. Way back the year 2017, Judiciary introduced the Cadis and Magistrates Registry Manual, which then were the tool that we use at the registries. Come the year 2022, that registry manual was reviewed or revised. And then in 2023, we started implementing the same. I think it was June 2023, we started implementing the same. The registry, according to that registry manual, is only for members of staff working at that particular station. But now, there are other stakeholders who require services at the station. What did we do? Two things. One is that we then designated an office of the court administrator where the probation officers don't have to go looking for files at the registry. All they need to go is to visit the court administrator's office, which is much more convenient and comfortable to them, and then they can note. And that is what we've been doing. But somehow, I've never understood why other people, other than judicial staff, want to get to our registries. If there's anything at Eldoret Law Court, when I went there, we had a high number of missing files. But since the implementation of the revised registry manual, that thing has come down, and we're still able to serve outside the registries themselves.
Okay. I'm satisfied with your answer. I think other than that, the other reports we received about your leadership skills and management at the station are quite impressive, so keep up the good work. My final question to you is about corruption in the station, and according to the last report that was shared, it was quite high at 11.43 against 7.03 for all magistrate courts. Any reason as to why this would be the case?
Thank you again, Commissioner. A very good. Eldoret Law Court, about 2.5 years now. The corruption index was at 15. We were able to put in place mechanisms, including now this one of not allowing people to go to the registry, in tackling the issues of corruption. I had promised myself, and even during my inaugural speech to the Court Users Committee, that we had to bring down that index of corruption to almost 3, where I was at Ogembo before I left for Eldoret Law Court. We have put in place a number of mechanisms, but logistically, Eldoret sits in 4 different locations. Eldoret Law Court are in 4 different locations. There is the Chief Magistrate's Court where I preside. There is the County Court, which is at the Governor's office. Then there is the Superior Courts, which sits at 2 different places. We have tried with the leadership of Justice Nyakundi to at least make sure that first and foremost, we are facilitated with relevant court administrators that can help us monitor. Because when I go to court and my brother Justice Nyakundi goes to court, whatever happens in the corridors, sometimes you don't get to know. But believe you me, Commissioner, we are even prosecuting brokers that have been arrested within our court precedents, trying to take advantage of litigants. I installed CCTV cameras when I went to Eldoret, and those has really helped us to try and bring down on that vice. But we are still a long way to go. But I'm sure I'd promised that 3 years will bring it down. I still have about 6-7 months before my 3 years term is over. That is,
okay.
Yes.
Okay, I'm hoping the next report will be positive. But keep up the good work once more, and wish you well. Thank you, Chair.
Thank you very much, Commissioners, and thank you, Honorable Mikoyan, for an interesting interaction with you this morning. On behalf of the Commissioners, I thank you and commend you also for the good work that you are doing to transform the Eldoret Law Courts, the initiative you are taking to make sure that the construction of the court moves according to schedule and it doesn't become one of these white elephants that we've been nurturing. So we wish you well. And before you leave, you have an opportunity also to ask us a question.
My Lady Chief Justice, mine is not a question, but to thank the Commission, for giving me an opportunity to appear before the Commission. I'm happy. It's my first time to be here in this setup, and I really appreciate the good questions that I've received from each and every Commissioner. And I also wish you the very best as you deliberate on your mandate. Thank you.
Thank you. Take our greetings to Eldoret.
Accepted, my
Have
lady.
a very nice day and a very nice weekend.
Thank you, my lady.